Thank you very much, Charlotte, for this presentation of EUniWell Talks and of myself. I'm very happy and honored to be here this morning and to be the first to speak during this social talk. So I'm very happy, and I'm going to try to respect the 40 minutes limit, but I'm not exactly sure about that. But I'll try to not be too long. So I'm going to talk about fighting discrimination in Europe this morning, and especially try to give you an introduction to the EU's legal framework on discrimination. But as it is an introduction, I thought it could be good to tell you that there are two main frameworks in European law to fight against discrimination. The Council of Europe, that is made up of 46 member states, and which is the arena where the European Convention on Human Rights has been negotiated and created, and where the European Court of Human Rights in Strasbourg is mentioned. And also, the Council of Europe has created the European Social Charter that has provisions on discrimination. So this is the first framework. We'll just say a few words about this one, and then I'll focus on the European Union. That is a very important tool to fight against discrimination. As you know already, probably there are 27 member states in the European Union, and the main sources now, at least the primary sources, are the Treaty on the European Union and the Treaty on the Functioning of the European Union, but I'll give you more details on that in a minute. But first of all, just a few short words on the Council of Europe that is not to be confused with the European Union. As you can see on the map, there are many member states. And in the European Convention on Human Rights that all law students already know, but in this convention, we have a provision in Article 14 that prohibits discrimination. It says that all the rights of the convention, especially mainly there are political rights in the convention, but not only, all the rights in the convention may be secured without discrimination on any ground. And we have a rather long list: sex, race, color, language, and so on, and other statutes. It means that this list is non-exhaustive, but this provision cannot be used alone. You have to combine it with other provisions of the Convention on Human Rights. And we have also another provision in this European Convention, in protocol, actually, that has been added to the Convention in 2000. And here it says that the enjoyment of any right set forth by law shall be secured without discrimination. And then again, we have a list that is not exhaustive either. This is here a general prohibition on discrimination. This provision can be used alone, but it hasn't been signed and ratified by all the members of the Council of Europe. Only 20 members of the Council of Europe out of 46 have signed and ratified it. I know that France hasn't ratified it because it says that there is already a sufficient framework to fight against discrimination, and ratifying it would worsen the caseload before the European Court of Strasbourg, the Court of Human Rights. So this is about the European Convention on Human Rights. We also have the European Social Charter. The European Social Charter was adopted in 1961. It had no provision on discrimination, but this charter has been revised in 1996, and we have a provision in Article E that is quite similar to Article 14. And here it means that it has to be combined with other provisions. The European Social Charter focuses on social rights linked to work, but not only. But here, about the European Social Charter, what is important to remember is that the European Court of Human Rights has no jurisdiction. It is a special committee, the European Committee of Social Rights, that is made up of independent experts that check that member states respect this provision. The problem is that this committee has no binding powers. It just sent recommendations to member states of the Council of Europe that has ratified the convention. So this is probably not enough to secure non-discrimination. And the Council of Europe also has been the forum to negotiate many other conventions that some of them have provision on non-discrimination, and some of them focus on specific issues linked to non-discrimination. So we can mention the Convention on Protection of National Minorities, or another against trafficking in human beings, or even another convention, the Istanbul Convention, which aim is to prevent and combat violence against women, and especially domestic violence. And the European Union is part of this convention, is a party to this convention since 2023, and it gives me a transition to introduce the second framework, the one I'm going to focus on now, the European Union. Many of you probably already know the European Union quite well, but if you do not, just in few sentences, the European Union is a 27 member states organization. And what is important, the Union claim that it is specific because it has very important normative power. And its decision, at least the legislative decision, are taken by the European Union Council, the council made up of ministers of member states, and by the European Parliament, which is very specific because it's directly elected by the EU citizens by direct universal suffrage. And what is important is that the effectiveness of European Union law is secured by a strong judicial control made by the Court of Justice of the European Union, and which is made of the court and the General Court. And EU law, to be that effective, is based on general principles such as direct effect, and primacy. It means that EU law is superior to national law, and under some conditions, you and me, we can invoke European law before national judges. So this is quite an effective tool, and it has many provisions on discrimination. But discrimination in the European Union, in the European Economic Community at the beginning, has been a concern since the beginning. But at the beginning, with the Treaty of Rome in 1957, the European construction, the EEC, had only an economic vocation. So there was no provision to fight discrimination in a sort of human rights promotion perspective. The ambition there was to create a common market. So the focus on discrimination was all about removing barriers to trade. So there were no discrimination on goods, but it's not really our concern today. It meant that goods could move freely without limitation based on their country, European country of origin. What is more interesting for us is that the treaty at the beginning set the basis to create the free movement of workers, the freedom of establishments, and the freedom to provide services. Free movement of workers, it concerns employed workers. Freedom of establishments concerns more undertakings or independent workers that want to establish themselves in another country than their country of origin. So I'm just gonna focus for a few words about the free movement of workers, because in the Treaty of Rome, there were actually only two main provisions on discrimination against persons. It concerned mobile workers, so the free movement of workers, employed workers, I'm going to say a few words about that, and the other provision concerned the pay of men and women. So first of all, the free movement of workers. I just put the current article of the Treaty on the Functioning of the European Union, the current article in primary law, but it's not that different from the first one. So what does it say? That free movement of workers shall be secured within the Union. It means that if you are European, if you are a national of a member state, you can go to find a job in another member state freely, and there is no discrimination based on nationality between workers of the member states. And it concerns employment, remuneration, and other conditions of work and employment. And this provision was completed, more specified by a regulation, a piece of legislation adopted by the EU institution based on the treaty and on this free movement provision. And it says that, so this first regulation was adopted in 1968, and then it was replaced by a new one in 2011. And it says that this abolition on discrimination based on nationality means that people, workers, must not be discriminated against when they seek employment, when it comes to remuneration. I mean that if a Spanish woman, for example, comes to France to work in university or in any French company, her salary will have to be the same as a French worker under the same conditions. This is the same for conditions of work and tax benefits and access to housing, access to education, and so on. Also, we have another provision since the beginning, since the Treaty of Rome, and it concerns equality of pay between men and women. So I put the article EEC, but now of the EEC Treaty of 57, but now you can find it in article 157 TFEU. What does it state? It establishes the principle of equal pay for male and female workers. And what is interesting is that this provision was at stake in the Dufresne case before the European Court of Justice in 1976. And this is quite interesting because in that case, the Court of Justice talked about the objective of this provision. Of course, the objective of this article on equal pay is social, is to ensure equality between men and women. But what is quite striking is that when you read the case, you see that the aim, I've put in the slide, the aim of Article 119 is to avoid a situation in which undertakings established in member states suffer a competitive disadvantage in intra-community competitions as compared to companies that have not yet eliminated discrimination. So here the goal is to avoid that companies that ensure equal pay are not suffering disadvantage, competitive disadvantage as compared to the others. So the objective is not only social, it's also economic. Well, it strikes me, and the social objective here seems rather subsidiary, accessory. It comes second. So of course, it's good for women because the rights exist. But after all, it favors women's rights. But so we can say it's okay. But what is interesting is that it can also be economic reasons, can also be a reason to postpone the realization of equal pay. What is interesting in that case is that the court went quite far because it recognized that this article of the Treaty on Equal Pay has direct effect. We call that direct effect. It means that you can directly go to the court before your national judge, before the court that is competent as it comes to working issues. In France, it would be the Conseil de Prud'homme, for example, and rely directly on this treaty to force your employer to pay you the same as male, for example. And here, the court said that this article has direct effect. So this is really protective of women's rights. But the court didn't go as far as it could have, because it said that this interpretation that it has direct effect would only work from the date of the judgment, from 1976, not from the entry into force of the provision. The provision entered into force in 1962. But normally, usually, the interpretation of the court is retroactive. It means that it applies from day one of its entry into force. Even if the interpretation was given later, it applies from the beginning, from the entry into force. But here the court said, no, for this time, for this provision, directive A will be postponed to later, to the date of the judgment, because otherwise the women would ask for the salary that they could have earned before if they were paid equally than men, and it would risk to put the companies, the undertakings concerned, in a very bad situation, financial situation, and even risk them bankruptcy. So then economy was still, very pregnant in this case. But then, as the treaties were modified, we moved towards a more integrated perspective as it comes to improve equality. So it's an economic perspective still, but we move towards a bit more political perspective. So first of all, we have the creation, not necessarily first of all, but we have the creation of the citizenship of the European Union with the Maastricht Treaty. It gives you, if you are European citizens, political rights, election rights, especially to the European Parliament and so on. But it's not my focus here. It also gives you civil rights, the right to free movement, irrespective of your professional status within the entire European Union. And it prohibits discrimination on the basis of nationality in all situations under the scope of application of EU law. So it widens the fight against discrimination on the basis of nationality. And also, the social competence of the European Union was deepened with the Treaty of Amsterdam. And we now have Article 19 TFEU, which is very important provision of the treaty because it gives the European Union a general competence to fight against discrimination in a social perspective. So maybe now I can give you a quick look on the current provisions that we find in the treaties to fight against discrimination. First of all, we have the European values in Article 2 TEU. We talk about the values a lot at the moment because some countries such as Hungary or Poland, mostly Hungary now, are not respecting the rule of law values, and democracy is at stake. But there is also the principle of equality that is enshrined in Article 2 and non-discrimination and equality between men and women. So these are values of the European Union. Also, in Article 3, we can find the goals, the aims, the objectives of the European Union. And it states that among its objectives, there are many more, of course, but amongst its objectives, the European Union shall combat social exclusion and discrimination and promote social justice and equality between women and men. So equality is an objective of the European Union. Also, we have the European Charter of Fundamental Rights. The Charter was adopted in 2000 and is in force, not in force, but it's binding. It means that EU institutions and member states, when they apply EU law, must respect it since the entry into force of the Treaty of Lisbon in 2009. And we find several provisions when it comes to non-discrimination in the Charter. Article 20, equality before the law. Article 21, any discrimination based on any ground, such as sex, race, color, and so on, shall be prohibited. Then, if we move to other articles, we have Article 23 that establishes equality between men and women in all areas, including employment, work, and pay. So we go further than pay, just employment, work, and pay. All the provisions are important as well, the rights of the child, elderly, integration of persons with disabilities, and so on. And as I said, when the EU legislation acts, they must respect these principles. They cannot adopt a piece of legislation that would contradict the principle of equality, the principle of equality between men and women, and so on. And member states, when they implement EU law, they must respect it as well. So we have also rules that say that the EU, when it acts, it must take into account equality. So it's in a way to try to reach the objectives of Article 3. This is called mainstreaming. It means like in all its activities, the European Union must make sure that it takes into account equality and it tries to reach the objective of equality. So we have it as it comes to gender in Article 8 of the Treaty on the European Union. The Union shall aim to eliminate inequalities and to promote equality between men and women in all its activities. And then in Article 10 TFEU, we have the principle of equality mainstreaming. In all its policies and activities, the Union must aim to combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age, or sexual orientation. And Article 18 of the TFEU say the same thing as it comes to discrimination on the ground of nationality. So here we have a general approach, but these provisions cannot be relied by individuals before national court. They are just general provisions that do not give extra competence to the European Union. It's just expressing an objective and not giving a new competence to the European Union to combat discrimination, to adopt specific acts aimed at combating discrimination. But we have this ground for legislative action in the treaties. We have provisions that give the competence to the European Union to act against discrimination. Here, as it comes to discrimination based on nationality, in Article 18 TFEU, it states that the ordinary legislative procedure is used to establish rules to prohibit discrimination based on nationality. The ordinary legislative procedure in the European Union, not explaining it in details, but it means that the Parliament, the European Parliament elected by the citizens, and the Council, means the ministers, are on an equal footing. So it's quite important because it gives a voice to the representative of the citizens, of the EU citizens, through the Parliament. Another provision, which is maybe the most important, is Article 19 of the TFEU. It sets the legal basis to adopt rules or as it comes to other grounds than nationality for discrimination. So here we do not use the ordinary legislative procedure, but we use a special legislative procedure. And this is an issue because here the Council must act unanimously. The ministers must all agree. All the member states must agree to act, to adopt action, to adopt legislative acts as it comes to discrimination based on sex, racial or ethnic origin, religion or belief, disability, age, or sexual orientation. So this is much harder to reach than discrimination based on nationality. So these provisions, 18 and 19, they do not give subjective rights. You cannot use them in front of a national judge to claim that you've been discriminated against by the states or by your company, your employer, for example. They are not self-executing as opposed to the different case and the equal pay rule that is in the treaty. But it gives the competence to the European Union to act. And on this basis, the European Union has adopted several directives in secondary legislation. So we have several directives. I promise I won't explain it all in details, but the directives have been adopted in the 2000, and you see they are separated as it comes to the ground for discrimination. So we have the first one I put on the slides is the directive on the ground of discrimination on the ground of race or ethnic origin. Second one, 78 directive, is against discrimination at work on grounds of religion or belief, disability, age, sexual orientation. It's called the General Framework Directive because it sets several bounds in one document. And then the two other directives, they concern equal treatment of men and women at work, not only about pay, but all working conditions. And the last one is about equal access to goods and services for men and women. I'll say then a word about proposal from the Commission to have a general directive, but it's never been adopted because the Council blocks it. So I'll be quick, but this first directive, the 2078 directive, it sets a general framework for equal treatment in employment and occupation. So its scope of application is employment. So it concerns work, actually. Work, but the legal form, which is in which it is providing, in which work is providing, is not important. You can be an independent worker, you can be employed, you can be in a public service, you can be in a private undertaking. This directive applies to you, and it concerns pay, of course, but also employment condition, working conditions. So it concerns the selections of candidates. You cannot be discriminated against because of your because of your age or because of your religion to get a job. It cannot be a ground for discriminating you. Or also you cannot be dismissed, fired, because of your beliefs, religious beliefs, for example. So we have a list of prohibited grounds for discrimination that is quite wide: religion, belief, age, disability, and sexual orientation. The Racial Equality Directive is limited to racial or ethnic origin discrimination. The scope of application of this directive is a bit wider because it concerns work, whether public or private undertakings, but also other areas. It concerns social protection, including access to medical care. Also, it includes social benefits, access to education, and access to goods and services, including housing. It means that if you want to rent an apartment, you cannot be discriminated against because of your racial or ethnic origin. So this is a rather protective directive. The idea behind that is that to find a job, it is necessary also to have access to healthcare, education, and housing. The aim of this directive, having a job cannot be separated from other concerns such as access to health and education and so on. So this is the most protective directive. Then the Gender Equality Directive, I just put them both here. The first one is about employment and occupation. Actually, there were directives before, but this one aims at improving the situation, and it covers both employment and access to social security. And the other one, the Directive 2004, covers access to goods and services. It means that you cannot be discriminated against because you're a woman to access specific services or to access good. But here, the protection is not as wide as the Racial Equality Directive. It doesn't include access to social benefits, such as healthcare and education. Maybe this is a bit hard to understand. So as this directive, they cover several scopes of application, maybe a chart can help to understand it better. So if you try to read it, you can see that race and ethnicity discrimination on this basis is prohibited on several aspects, that people are protected against this form of discrimination as it comes to employment, social security, access to goods and services, and social advantages such as education. As it comes to gender, the two directives protect quite well, but not access to education, for example. And as it comes to religion, disability, sexual orientation, and age, we only have this directive that only covers employment. So these people that might be discriminated against on this basis are not protected as it comes to access to social security, access to goods and services, and education. The Commission wanted to cure that problem, to end that hierarchy of grounds problem. And it made a proposal because, as you may know, the European Commission has the monopoly of the legislative initiative in the European Union. So it made a proposal to put all the grounds at the same level, to make sure that the protection is the same for everyone, whatever the ground is. But the problem, as I said earlier, is that it's necessary to reach unanimity before the Council of Ministers, and it was never reached. So the protection has not been extended. So this is where we are now. So now that we have seen these directives, maybe I can say a few words on the content of these directives. Then I'll be brief and just focus on key elements. First of all, I'll mention the distinction between direct and indirect discrimination. Then I'll just say a word on the evidence issue, the burden of proof. And to conclude, I'll say just how it works as it comes to applying this directive and invoking them before the judge. So first of all, about discrimination. What is discrimination? The directive establishes a distinction between direct discrimination and indirect discrimination. So as it comes to direct discrimination, it means that its prohibition involves to treat equally people that are in a comparable situation. And it prohibits to treat someone with protected characteristic less favorably than others. So this is the explanation, but maybe it is easier to understand it with an example. So for example, if the owner of a restaurant refuses to serve a Black family, saying that it doesn't want migrants in his restaurant, then this is an unlawful direct discrimination based on race, here in the provision of a service. Okay, then another example, the human resources director of a company refuses to hire a woman, maybe as a carpenter, because it says that this is a male's job. This is direct gender discrimination in access to employment. This is pretty straightforward. This is direct because we know the reason. The reason is gender, is race, is disability, or so on. So this is direct discrimination. We have cases, many cases. I just chose these two to give you an example. Here in the Ferrin case, the employer publicly stated that he would not recruit employees of a certain ethnic or racial origin. Here, this is direct discrimination in recruitment within the meaning of the Racial Equality Directive. We have another example in the Coleman case. A woman was dismissed, fired, because of her child's disability, because she had to take time to take care of the child. And the question was, can we protect the woman against this discrimination on the basis of disability? Because she was not herself disabled, it was her child. So can we protect such a sort of discrimination by association? And here, the court doesn't use the term discrimination by association, but it finds that the prohibition of direct discrimination is not limited only to the person who have the characteristic of being disabled. Here, it applies the fight against discrimination, the prohibition of discrimination applies to the person that takes care of this disabled person. So this is direct discrimination. The question is, can we, in some situation, justify those discrimination? Can we, in some situation, admit such a discrimination? in principle, direct discrimination cannot be admitted. But there are exceptions, very few, but they exist. And they exist only where the justification is provided for in the directive. The directive must set the cases where such a justification is admitted. And in the employment directives that I explained earlier, we have a justification when the criteria at stake is a genuine and determining occupational requirement, when it is necessary to discriminate against for that specific job. For example, it's easier to understand with an example, the age limit in the police or the army, because you have to be physically fit for the job. For example, it's necessary for your security and for the security of the others. Also in theater, for example, for a specific role, or if you are a model in the fashion industry, then it can be justified to set gender or age requirements, but it cannot be general. It is only limited. Also, in the General Framework Directive, we have two specific grounds for justification of discrimination. In Article 4, it says that activities within churches or organizations based on religion. In churches, it is possible to take into account the person's belief to hire that person. It is possible to require that a person is questioned to work in a Christian church, for example. Another example is age. Age can be admitted at a difference of treatment if it is objectively and reasonably justified within the context of national law. Now, I just move to indirect discrimination, which is a concept that is more subtle, that is harder to understand. But again, example may help. Here we have an apparently neutral provision, criterion, or practice, something that is apparently neutral, that is applied to person of a specific protected group. So apparently there is no discrimination because it seems neutral when we look at prima facie at first sight. But when applied, that provision has the effect to put that group in a particular disadvantage. And we can qualify it as indirect discrimination when it cannot objectively justify it. So here what is important is the appearance of neutrality. Again, it's easier to understand with an example. The prohibition of headscarves, Islamic headscarf, for example, may cause an indirect discrimination based on religion because it disadvantages person who belong to a specific religion, for example, Islam. So this is apparently neutral, but actually it targets certainly a specific group. And here the difference with direct discrimination is that it is easier to justify it, to admit such kind of discrimination. We have two conditions to admit justification to admit such indirect discrimination. The discrimination must follow a legitimate aim. So the objective at stake must be legitimate, and the means to achieve this objective must be appropriate and necessary. If there is another solution to reach that mean of that legitimate mean, then we must use another solution that would be less constraining for the people. But again, it's easier to understand with cases. I took the example of religion and the Islamic headscarf to make it clear. So we have a case of the Court of Justice of the European Union. Actually, we have many cases. I just chose this specific one, the Wabe case of 21. Here, it was a company in the private sector. And here it was against the issue at stake was, is it possible in a private nursery, in crèche in French, a private nursery, to wear an Islamic headscarf? Here the issue for the court was to balance between the religious freedom of the employee and the entrepreneurial freedom of the company. The company wanted to establish a requirement of neutrality for the employee because it says that this is a day nursery for babies and their parents hold the right to educate their children in accordance with their beliefs. So balance between freedom of religion and entrepreneurial freedom. So here it is an indirect discrimination because the company required neutrality. It wouldn't be admitted if it was only to prohibit Islamic headscarves. But here it's a total neutrality that is concerning all religions or beliefs. So this is admitted. But can it be justified? Is this will of the company justified, this will of neutrality? Here the courts established conditions to admit such requirement of neutrality in a company. First of all, it covers all visible form of expression, not only Islamic scarf. So it must cover all religion and visible expression of religion. And also, this requirement must be applied systematically and consistently. So we have the rule that is established by the company. The rule must be targeting any belief, not only Islam, not only the headscarf, but all beliefs. But it's not only the rule, it's also the way it is applied. The company must apply it to all the employee, or at least under the same conditions, and consistently, not only focusing on headscarves in practice. So it must be applied systematically and consistently. So this is the conditions to justify and to admit such a requirement of neutrality, such an indirect discrimination. And we have another case that is more recent of 2023. It's called OP Recommendance. Here the difference was that it was in the public sector. The previous one was the private baby nursery. Here it is in public sector. And another issue was that it was a back office worker. She was a lawyer. She was not meeting clients or users. She had no contact with the public. And she wanted to wear her headscarf. But the commandants, the public service, refused to grant her that right to wear her headscarf. And they changed the internal rule to put a requirement of strict neutrality for the workers. And the Court of Justice was asked to say if it was contrary to EU law and to the directive or not. And the court said it was okay to have such a strict neutrality. It gave a wide margin of appreciation to member states. And here we have, it was in Belgium, but it can also be linked to the French principle of laicity, which is a constitutional principle. So here we have the link with EU legislation, the balance between fights against discrimination and constitutional choices of member states and the respect of their sovereignty, because member states can have a different approach towards religion, separation of the state and the church, and their constitutional identity that the EU is bound to respect. But again, the strict neutrality is accepted to the condition that it is covered concerning all beliefs and that it is applied systematically and consistently to the workers. And the national judge has a role to make sure that this is proportionate and necessary. Just a few words. I'll be quick. I just need 5 more minutes if it's okay with you, Charlotte. Just a few words on the burden of proof, because one issue with discrimination, when you are the victim of discrimination, it's extremely hard to prove it. In any circumstances, you cannot be in the mind of the author of the behavior that you think is discriminatory. So it's very hard to prove the intent. So the principle here is that we reverse the burden of proof. The directives that I explained earlier, they set a rule saying that member states must make sure that the burden of proof is easier for the victims. It's enough to have facts that allows us to presume that there has been a discrimination. And then it is the respondent, the author, that we think, the presumed author of discrimination, that has to reverse the proof, that has to prove that it was not discriminatory. But this only applies in civil proceedings. In civil proceedings, just like working litigation, to get damages, for example, not in criminal procedures, because criminal law requires strong evidences and has specific rules on the matter. I can give you an example to explain the idea of the reversal of the burden of proof. You are a woman and you're an employee and you think that you are paid less than your men colleagues because you are a woman. You won't have to prove that the company didn't want to pay you just because you are a woman, because it's impossible to prove. You just have to give facts to say that, look at my paycheck, I'm paid less, my pay is lower than my colleagues, the men in the company. And you have to show that the work you do is of equal value. And then this is the employer that will try to rebut the presumption, try to prove that it is not discriminatory, but it is the difference in pay is justified by objective reasons, like, for example, a difference in qualification, a difference in professional experience, and so on, but not justified by your gender. So the idea is to make it easier to prove. So that was just a few words on the burden of proof. Now we have seen the content of the directives and the issue they try to solve. But the problem with directives, they can be hard to rely upon. So it's now important to understand how they work in practice and how the rights can be effective. If you've studied EU law, you know what a directive is. You find the definition in Article 288 of the TFEU, and you know that it sets an obligation of results to the member states, but the member states are free of the means and procedures to reach this result. It means that the member states, they have a deadline, they have a time limit to achieve that result, and they are free of the way they reach it. But within the time limit, they must transpose, they must make this result real in national law. They must transpose, we also say implement the directive in national law. And once it's done, once they have put the directive's provision into national law, you just do not even realize when you read national law that it comes from a directive. You just invoke national law. And for the French students, we have many provisions in the labor code that are transposition and implementation of EU directives. But if you do not know it, you do not even notice it. So when the directive is properly transposed by member state, you just rely on national law. The problem is that member states quite often, they do not transpose the directive in time, or they do not transpose it properly. So what can we do here? Can you rely on the directive that has not been transposed? The answer is complicated. The answer is complicated. Actually, you can invoke the directive if it's not been transposed by the state, if it's against the states. If you want to rely on the directive against the state, it means that if the state is the author of discrimination, you can rely on the non-discrimination directives. This is the result of case law and the invocability of directives in vertical disputes. Vertical because you are the individual and you go towards the top against the state. And it's ascending. So you can invoke clear, precise provisions of directives in vertical litigation, you against the states. But the reverse is not true. A state can never invoke a directive it has not implemented because it would invoke its own fault. So here you can invoke a directive against the state. But as it comes to discrimination, it's important to know that you can invoke it against the state if the state is an employer, also against territorial authorities, just like in the case Commune Nantes in a region or city. You can invoke the directives against a state. It means that I'm employed by the French University. This is a public service. If I feel that I'm discriminated against because I'm a woman, as it comes to my pay, for example, I can invoke the directive against the state, against the university, even if the directive were not transposed in national law. It is transposed, but if it were not, I could. But the problem is that I cannot invoke directive in an horizontal dispute, private to private, individual to individual, company to company, or individual to company. When I say company, I mean private company. It's not possible. The court refused the invocability of directive in horizontal disputes in a case called Faxinidori in 1994. So here you have no solution if the state hasn't transposed the directive in time. Then later you can try to go to the national judge to claim compensation, damages against the member states because it has not implemented the directive, but you'll just get damages afterwards in a case-by-case basis. It's the Frankovic case that allowed it. Also, the European Commission can bring a procedure, an infringement procedure against the member states, so that the member state can be sentenced by the European Court for not transposing the directive, but it won't change your situation directly. So this is an issue, and we can see that it leads to an inequality between workers in public and private sector. I work in the public sector, I could invoke directive against my employer, against the university, that is to say, the state, if I am discriminated against by the university. But if you work in a private school, in a supermarket, or any private undertaking, you could not rely on the directive directly, which is an issue. This is really an issue. But as it comes to equality directive, the Court of Justice of the European Union has tried to mitigate this solution. The equality directive has been indirectly, subtly applied in an horizontal dispute with the Mangold case. In the Mangold case, we had a 56-year-old German man. He was employed in a law firm on a 2-year fixed-term contract. It means a limited time contract. And this limited time contract were established by an act, a law passed in Germany, saying that for the elderly, the people not that old actually, but for the people that are more than 52 years old, to promote their employment, they can be employed with fixed-term contract, while the rule for any other people is indefinite-term contract, permanent contracts. And Mr. Mangold thought that it was discrimination on the ground of age. And indeed, the Court of Justice said that this kind of provision, saying that the older people, they can be employed with a fixed-term contract and not permanent contracts, is a discrimination on the ground of age, and it contravenes the directive. But this is a horizontal dispute, Mr. Mangold and the law firm, private undertaking. So it's not possible to rely only on the directive. And moreover, the transposition time had not yet expired. But the court found a way, anyway, to protect Mr. Mangold. It said that non-discrimination on the ground of age is a general principle of EU law. It says that the directive does not create that principle of non-discrimination by itself. This principle pre-exists in various international instruments and in the constitutional traditions that are common to member states. So that principle exists, it's not written, but it exists. And the consequences, sorry, I have typos in my slide, I'm very sorry. The consequences are that national courts must set aside any provision of national law that would conflict with the directive, and even before the period for implementation of the directive has expired. What it means is that the German judge must set aside provisions saying that people that are older than 52 must have a permanent contract. If you fixed term contract, sorry. So if you put aside that rule of fixed term contract for the older workers, then you get back to the normal rule being permanent contracts. So Mr. Mangold can rely on the non-discrimination directive to have his rights respected in national law. And I'll be quick, this case was confirmed in 2010 in the Kukuk-Devechi case. I'm just summarizing here the difference. There are several differences, but the most important one is that the court also relied on the Charter of Fundamental Rights, Article 21, that now had the same legal values as EU treaties. But it was confirmed in that case. Just as a short conclusion, I have presented the directives and the framework. I said that they were not enough because they do not cover all the situations where you can be discriminated against. Also, the European Union has tried to have a more comprehensive action as it comes to discrimination. And I just put the example on gender to ensure gender equality. A new directive has been adopted in 2022 to ensure gender balance among directors of listed companies and other measures. And for example, at least 40% of non-executive board members must be from the underrepresented sex, meaning women, or 23% among all directors of the underrepresented sex before 26. We also have a directive that is pretty new of this year to combat violence against women. And it imposes to member states to establish in their national law, if not already done, sanctions. It imposes them to criminalize violence against women, certain kind of violence against women, just like genital mutilation, forced marriage, revenge porn, stalking, and so on. So member states must create sanctions and measures of prevention as well. And as I said at the beginning, the EU also acceded to the Council of Europe Convention of Istanbul as it concerning violence against women. So it's not only the but you'll have many opportunities with the next social talks to see how the EU is fighting against discrimination, and it goes beyond social policy of the European Union. It can concern asylum seekers. We have a case of 24 where a Turkish national of Kurdish origin married by force and subjected to domestic violence was qualified as a refugee by the court, and we have a very recent case of the Court of Justice of the European Union as concerning Afghan women. And basically, to summarize it, the court said that you are a woman, you are Afghan, it's enough to be a refugee in the European Union. When member states can rely only on this criteria to allow you to be a refugee in the European Union, because the court didn't say gender apartheid, but it's the idea. In Afghanistan, women face a gender apartheid. And there are also another important case that was released last week. Here it comes to the right of freely moving and residing within the European Union, and it concerns gender recognition. Here it was a Romanian citizen who moved to the United Kingdom before Brexit. So this person moved to the UK, and there it got a gender change in its birth certificate. And then this person came back to Romania, but didn't manage to get the change of gender in Romania. And the court said that it's unlawful to refuse to register the change of gender acquired in another member state, the UK, in Romania, because it affects the rights of this person to freely move within the EU. took this example to show you that the fight against discrimination has many aspects and can touch many areas. I hope I was clear enough, and I hope it was of interest to you, and I thank you very much for your attention.